Yes, so welcome to our today's session. And in this session, I want us to proceed to topic number two, which is basically a very interesting topic because we are going to discuss on the formation of companies, specifically in accordance with the provisions of the Companies Act, or actually in accordance with the Companies Act of 2015. So therefore, in this particular topic here, basically, we're going to look on the procedures which are followed whenever a company is to be registered, and also maybe some of the documents which you need to prepare and actually file with the person who is called the registrar of companies for the company to be registered with the registrar of the company. So if you can be able to recall, we say registered companies, which are companies formed and also incorporated in accordance with the provisions of the Companies Act, they are registered by a person known as the registrar of a company. So those are basically some of the aspects you're going to discuss as far as this topic number two is concerned. But first of all, I want us to define something called the promotion of the company. So what do you mean by promotion of a company? Promotion of the company basically refers to the comprehensive or basically to the entire exercise through which a company is incorporated and actually brought into existence and also enabled financially through the issue of a prospectus to the members of the public if that company is a public what? A company. So we are saying promotion is the entire, it is the comprehensive task through which now the company is incorporated, brought into existence, and also enabled financially if that company is, or actually enabled financially through the issue of a prospectus, if the company is actually what? Is actually a public company. So therefore, this is that particular entire process, process through which a company is actually what? Is actually formed. And actually, we're going to see that this particular process of forming a company basically involves so many things. It first of all undertaking something called the name search, a reservation of the name, then preparation of a number of documents, because whenever a company is to be registered, the number of documents which must be registered and filed with the registrar of companies. So once those particular documents have been prepared, they have been filed with the registrar of companies, the registrar will go through them. If he is satisfied, he will register the company, issue those who have registered that company the certificate of incorporation, and then if this company is a public company, the company to be formed is a public company, it must go ahead, issue a prospectus, inviting the members of the public to come and buy its shares or what? Debentures. The company will be able to raise capital through the sale of shares or through the sale of debentures. Once the company raises the required capital, then the company will be able now to kickstart its what? Its operation. The entire process, that entire process is basically what referred as what? The promotion. And actually, this process here, that is the promotion of the company, is actually undertaken by individuals who are known as promoters. So who is a promoter in this case? A promoter basically refers to any person who undertakes to form a company with respect to a given project and basically sets that company as a going concern. So a promoter, therefore, we are saying, is any person who undertakes to form a company, and basically set that company as a going what? As a going concern. So mean that if, for example, you are one of the person who is involved in the formation of the company, or basically you have undertaken to form a certain company, for that company to undertake a certain project, or maybe for that company to undertake a certain business activity, and you ensure the company has been registered with the registrar, the company has kick-started its operations, then in that case, you are known as a promoter. You are known as who? As a promoter. So therefore, it is that particular person who undertakes to form a company with respect to a given project and basically set that company as a going what? As a going concern. Now, in this case, whenever the promoters are basically forming the company, then in this case, we say that promoters are actually regarded to be the trustees of the company. So who is a trustee? Basically, a trustee is a person who is entrusted to do something on behalf of another what? A person. So therefore, the trustees here are actually regarded to be the trustees of the company. Whatever they do in the process of incorporating, in the process of forming the company, they must do it in the best interest of what? They must do it in the best interest of the company. Now, on the other hand, here we say that the relationship which exists between the company to be formed, and this person we are referring to as the promoter, there is a relationship, or that relationship which exists between these two persons, we refer to it as a fiduciary relationship. Fiduciary relationship. And actually, in this case, when we talk about a fiduciary relationship, this one we say is a relationship of trust, is a relationship of trust, because we are saying that a promoter here is actually a trustee of the company. He has undertaken to take all the necessary steps to ensure the company is registered. Whatever the promoter does in the process of forming the company, he do it in the best interest of what? Of the company. So therefore, in this case, a promoter is actually regarded to be a trustee of what? Of the company. And basically, as a result of this, the promoter is actually expected to undertake a number of duties as far as the formation of the company is concerned, or actually a number of fiduciary duties, but you're going to discuss on those particular duties of the fiduciary duties of the promoter later on. So, but it's very, very important for you to note that relationship which exists between the company to be formed and the promoter is a fiduciary relationship. Then what are the duties? What are the duties of the promoter during the promotion, or basically during the formation of the company? Now, the duties of the promoter generally are classified into two main categories. So these duties of the promoter are classified into two main categories. Number one, we have something called the fiduciary duties. And number two, we have the general, also known as the common law duties. Now, first of all, we can start by discussing on the fiduciary duties. Fiduciary duties, basically, we have said, these are those particular duties which arises out of the fiduciary relationship. Remember, in this case, we have said, if you are involved in the process of forming a company, you are then a trustee of that company. A trustee is basically a person who is entrusted to do a number of things for the benefit of another person. And therefore, the fiduciary, rather the promoter here, basically has the three main duties here, or three fiduciary duties. One of the fiduciary duty of the promoter is the duty of disclosure. So mean that the promoter here is basically, or do have the duty to disclose a number of things. One, the promoter should disclose any secret profit which he makes in course of his duty. So mean that if, for example, you are involved in the process of forming a company, and maybe you have made a certain profit, you have maybe made some financial, or you have benefited financially in the process of registering the company. In this case, you are expected to disclose that now to the other promoters. If you fail to do that, then you can be sued in a court of law, because you made you benefited financially, you made a profit, but you never disclose that now to the other promoter. So in case you benefit financially, you make a profit which is not known to the other promoters, you are expected to do what? To disclose that now to the other promoters. Number two, the promoter is also expected to disclose something called the personal interest. The personal interest in any transaction he is undertaking on behalf of the company which is to be formed. So meaning that if the promoter is undertaking a certain transaction on behalf of the company which is to be formed, but the promoter has some personal interest. Some personal interest means that once the transactions go through, the promoter will benefit indirectly, will benefit either directly or indirectly. So in such a case, we say the promoter, though he is undertaking a transaction on behalf of the company which is to be formed, the promoter has got some personal interest. So if that is the case, then the promoter is expected to disclose that to the other promoters. And actually, equally, if he fails to do that, to disclose his personal interest or to disclose that he's having some personal interest, then various legal actions can be taken against him by the other promoter. So therefore, that is basically the first fiduciary duty of this particular person we are referring to as who? We are referring to as the promoter. Number two is the duty to act bona fide. Act bona fide. Act bona fide. So what do you mean by the duty to act bona fide? It basically means that whenever you are acting as a promoter, and actually you're involved in the process of forming the company, you must act in the best interest of the company, or basically whatever you are doing as a promoter, it must be for the full benefit of the company. Make sure whatever you do as a promoter, it will basically or it is of the benefit to the company, not for your own benefit, not for you to benefit, but it's for the company to do what? For the company to benefit, for the company to be able to do what? To benefit. And number three is something called proper accounting, the duty of proper accounting. So basically, proper accounting comes from the word to account. What is to account? To account is basically whereby if you're given, for example, an amount of money to spend, assuming we come together and maybe we are forming a company, we give you, for example, 10,000 to be able to do a number of things on behalf of the company which is to be formed, then you must account how you spent that amount of money. You must be able to give an explanation of how you spent that particular amount of what? Of money. So therefore, a proper accounting is whereby the promoter is expected to do what? To explain how he spent any amount of money which was given to him by the other promoters, maybe to spend on behalf of the company to be formed. So therefore, in this case, we have those as the three fiduciary duties which are expected from this particular person known as a promoter. Recall, we have said that a promoter refers to any person who undertakes to form the company with respect to a given project and set the company as a going concern. But it's also important for you to note here that a promoter does not involve any person who is involved during the formation of the company in a professional capacity. What does that mean? It basically means that, for example, here we can come together, we decide to register a private company, but maybe in the process of registering a private company or in the process of forming a registered company, we engage a professional or maybe an expert, for example, a lawyer, to be able to do a number of things on our behalf, maybe to prepare a number of documents on our behalf so that we can be able to form that company. So that lawyer we have engaged is involved in the process of forming a company in a professional capacity. So in such a case, that lawyer is not a promoter because he's involved in a professional capacity, basically to do a number of things on behalf of who? On behalf of the promoter. So therefore, we have those three fiduciary duties. Next, I want us to look on the common law duties. Common law duties, we say that these are the general duties which are expected from the promoter during the formation of the company. So if we come together and basically we are registering a company, we are forming a company, which are the general duties which are expected from us. Number one is that we must come up with the name of the company, and have the name reserved. And have the name what? Reserved. So it's upon the promoters to be able to come up with the name of the company. They do something called a name search. If today you want to register in a business, you are required to come up with at least three names. Then you go to eCitizen, you fill in all those particular names and you do a name search. So one of the name will be approved, or maybe all of them can be rejected. So if all the names are rejected, you'll be required to come up with three other names. You do a name search. If one name is approved, then it will be reserved. It will be reserved for a period of 30 days. It will be reserved for a period of 30 days. So within these 30 days, no any other business, or actually no other application which is made by a person who intends to register a business, or actually such a name cannot be given to another a business, or maybe to another person. The name will be reserved for you for that period of 30 days. So therefore, one, the promoters must come up with the name of the company and basically have the name have the name reserve. Number two is that the promoters are the one who have the responsibility basically to prepare the constitutive document of the company. Constitutive documents of the company. So when talk about the constitutive document, we are talking of those particular documents which are regarded to be the constitution of the company. So this document, if you can be able to recall, they include the memorandum of association and also the articles of association. It is the responsibility of the promoters to be able to prepare this particular document, to prepare the constitutive document of what of the company. Number three, the promoters also have a responsibility to meet all preliminary expenses. To meet all preliminary expenses, all preliminary expenses. So what do you mean by preliminary expenses? Preliminary expenses are basically those particular expenses which are incurred during the formation of the company. If we come together, we want to form a company, we want to register a company, there are a number of expenses which we incur. For example, maybe we need to pay for the name search. You pay for around 1,000. Then from there, you also have to pay an amount of money to the office of the registrar of companies, around 10,000 or 11,000. And also we have other expenses which we incur during the formation of the company. It is the responsibility of the promoters to pay or to raise money to pay all those particular expenses. So they have the responsibility to do what? To meet the expenditure, to meet all the preliminary expenses of what? Of the company. The other general duty of the promoters is basically to appoint the first directors of the company. To appoint the first directors of the company. The first directors of the company are basically appointed by the promoters by the virtue of including their names, in a document which is known as MOA, Memorandum of Association, which is basically to be filed with the person who is called the registrar of what? Of the company. So the other general duty of the promoters is basically to register the company, with a person called the registrar of companies, So the promoters must ensure that they have undertaken all the steps and the company has been registered with the registrar of companies. So automatically for the company to be registered, application for registration will have to be done. The various documents which are required during the registration of the company will be filed with the person called the registrar of companies, and so on. So therefore, the promoters must do everything which is possible to ensure, or everything which is necessary to ensure that the company is basically registered with who? Is registered with the registrar of who? The registrar of companies. So the other general duty is basically number 6, to acquire assets for use by the company, So the promoters have that particular responsibility, have that duty to ensure that they have acquired assets which the company will be using once the company has started to operate. And then number 7 is to undertake transactions on company's behalf. So any transaction which is to be undertaken on company's behalf during its formation, for example, maybe issue of prospectus, if the company is public, and anything which is necessary, or any other transaction which the company needs to undertake during its formation, those particular transactions are undertaken by the promoters, but basically on behalf of who? On behalf of the company. And number 8 is to prepare a prospectus if the company which is to be formed is a public company. So if the company to be formed is a public company, the promoters have that particular responsibility to do what? To prepare a prospectus. What is a prospectus? A prospectus is a document, which is prepared by the company to be issued to the members of the public, inviting them to come and buy the shares or the debentures of the company. Because if you can be able to recall, in our previous session, we said that once a public company has been registered with the Registrar of Companies, a public company cannot be able to start operation until that company has received something called a trading certificate. So meaning that once a public company here has been registered with the Registrar of Companies, the Registrar of Companies will issue the promoters with something called the certificate of incorporation. But we say this company cannot start operation until it receives another, or until the company receives another certificate, which is called what? Trading certificate. Who issued this particular certificate here? Trading certificate. This certificate is still issued by the Registrar of Companies. The Registrar of Companies, once the company has been able to raise something called the minimum subscription. So minimum subscription, we said that this is the minimum amount of money which a company has to raise, and that is a public company has to raise through the issue of shares or debentures to the members of the public, which will be enough, number one, to pay for all preliminary expenses incurred by the company. I hope you can be able to recall what are preliminary expenses. I've explained that. Number two, to pay for any asset or property acquired by the company. Number three, to provide the company with sufficient working capital. So meaning that once this company is registered with the registrar, it must first of all issue a prospectus inviting the members of the public to buy its shares. And once that company has been able to raise that minimum amount of capital which is required, it will notify the Registrar of Companies. The registrar will go ahead and issue that company that trading certificate. We said that is the only time this company should be able to start operation. So therefore, these are basically some of the general duties of the promoter, and these general duties, we are referring to them as the common law duties. This is a very, very common question in the exam, whereby the examiner can require you to define who is a promoter and also to explain what are the duties of the promoter. We are going to look on some of the questions from the past papers. So therefore, it is important for you to note that a promoter has two duties: the fiduciary duties and the common law or the general duties. So we have talked about three fiduciary duties, and I think in this case we have talked about eight general duties, or basically eight common law duties. So next, I want us to discuss on something called, or we look on a number of things which must be done by the promoters and for the company to be registered with the Registrar of Companies, and also the company to be set as a going concern. So in this case, we can talk over the preliminary incidentals, to the formation of the company, to the formation of a company, to the formation of the company. Preliminary incidentals to the formation of the company. Generally, in this case, when we talk about the preliminary incidentals, this refers to what the promoters need to do, what promoters must do for the company to be what? To be registered, for the company to be registered, and basically the company to start operation. To start what? To start operating. So what need to be done by the promoters? And actually, we can be able to come up with some of things which the promoters need to do, maybe from their duties. From what? Their duties. But some of the main things which the promoters must be able to do for the company to be registered and to start its operation is basically to come up with company's name, to come up with the company's name, and basically have the name reserved. Have the name what? Reserved. This is very, very important. In fact, even before the company is registered, the first thing which the promoters must be able to do is to sit down and basically they come up with at least 3 names of the company, and then from there they proceed and undertake something called the name what? The name search. Number 2, The promoters will also need to basically determine, they will also need to determine whether the company to be registered will be a private company or basically will be a public what company. This is also key. This is also very important that promoters must be able to determine is the company to be formed, will it be a private or basically will it be a public company? So number 3 is to determine the liability of members. To determine the liability of members. So the liability of members, we said, is the obligation of the members to pay the company's debts in case the company is bankrupt, in case the company is insolvent. So therefore, we must determine whether the liability of members would be limited by shares, or basically it will be limited by what? By guarantee. So if you can be able to recall, in our first topic, we discussed what is the liability, or what you mean by the liability of members being limited by shares. And actually, we say that this is where the liability of members is limited by the amount unpaid on the shares which you hold. So mean that if, for example, you have been issued with a number of shares of the company, you have not fully paid for those particular shares, and maybe the company is not in a position to pay its debt, what happens is that you'll be required to come in as a member and you do what? You pay that amount unpaid on the shares you hold. If you have not paid, for example, 10,000 on the shares issued to you, you'll be told by the directors, can you bring this amount to help the company in terms of paying its debt? But if you hold some shares, you have bought shares in a company, the shares are fully paid, the company is not in a position to pay its debt, then in this case, you will not be required to come in and you contribute or basically pay any amount of money. Company limited by shares, we say that those companies, number 1, which do not have share capital. Number 2, the liability of members is limited by guarantee. During the formation of these companies, we say that each member undertakes or promises to contribute a certain amount of money to help the company in terms of paying its debt in case the company has been declared bankrupt or what? Or insolvent. So therefore, it is basically upon now the members, sorry, not the members, rather the promoters, to determine whether the liability of members will be limited by shares or by a guarantee. And finally, the promoters also need to do what? To determine whether the company will have share capital. To determine whether the company will have share capital. To determine whether the company will have what? Will have share capital. Will have what? A share capital. So remember, we said that there are those particular companies which do not have share capital. Companies such as or companies limited by guarantee, these companies basically do not have what? Share capital. So therefore, it's upon the promoters basically to determine, is the company or this company which you are forming, will it be having some share capital or what? Or not? Will it be having some share capital or not? So that basically what the promoters need to do so that the company can be registered with the Register of Companies, and the company maybe start what? Operation. Now, it is also important for me to mention that if, for example, you are a promoter, you're involved in the process of forming the company, it does not mean that you'll become a shareholder of that company. It does not mean that you'll become a shareholder in that what company, because if by the end of the day, you have not maybe subscribed or maybe purchased the shares of that company, you may not be a member of that what company. Therefore, because you have been involved in the process of registering or basically the process of forming a company as a promoter, then there are various ways in terms of how you should be rewarded for your services. So therefore, in this case, we can discuss on the remuneration. The remuneration to promoters. Remuneration to promoters. So the remuneration to the promoters basically here, we have said the promoters are basically supposed to be rewarded for their services. But in this case, it is also important for you to note that the promoters here basically are acting on behalf of a company which is yet to be registered. they are acting on behalf of a company yet to be registered, And actually, in this case, it's also important for you to note, before a company is registered with the Registrar of Companies, that company is not recognized as a legal entity. So a company will only be recognized as a legal entity once the company has been fully registered with the registrar. And therefore, in this case, we say the company which is to be registered do not have a contractual capacity, do not have the ability to enter into a contract with the promoters that company will be able to do what? To remunerate or basically to pay maybe a commission or, for example, some allowance or maybe a salary to who? To the promoters. But in this case, it is always fair that because the promoters have been involved in the process of forming the company, they must be rewarded. They must be what? They must be rewarded for their services. So in this case, we have various ways of rewarding the promoters, various ways of rewarding the promoters for their services. Number one, the promoters can be rewarded by being appointed as the first directors of the company. Appointed the first directors of the company. So once you are involved in the process of forming the company, because you're saying it's not a must by the end of the day become a shareholder, you can be rewarded by being appointed as who? The first director of the company. Number two, you can also be rewarded by being issued with some shares, which are known as the founder, or basically the deferred shares. What do you mean by the deferred or basically the founder shares? So these are those particular shares which are issued to the founders of the companies. Who are the founders of the company? The founders of the company are the promoters. So the promoters will be rewarded by being issued with the deferred or founder shares, of which basically these particular shares, one, they are issued to the promoters free of charge. And number two, the promoters will also be entitled to some dividends from the company after the company has paid dividends to the other category of shareholders, like the ordinary shareholders and the preference shareholders. But that is basically the other way how the promoters may be rewarded. Equally, the promoters can also be rewarded by being allowed to do what? Or they can be rewarded by doing what? By selling an asset, to the company at a profit, provided the profit is disclosed. The profit is disclosed. So as a promoter, you can actually be rewarded by being allowed to sell an asset which you own to the company at a profit. At a profit means that you can sell that asset at a price which is higher than its market value or than its fair value. But in this case, we are saying the profit which you are making, you must disclose it. You must do what? You must disclose that particular profits. Equally, number four, the promoters can also be rewarded by paid a commission, by paid a commission for facilitating a transaction between the company and a third party. So the promoters can be paid that particular commission because they have facilitated, they have undertaken a transaction with third parties on behalf of the company. On behalf of who? On behalf of the company. So that basically is the other way in terms of how the promoters can be rewarded. Number five is that the promoters can also be rewarded by being paid a commission for issuing shares on company's behalf. On company's what? Behalf. If the company which is to be formed is a public company, we have said that that company, before it can start its operation, it must be able to raise a capital we have referred to the minimum subscription. Minimum subscription basically, or that capital will be raised automatically by that company issuing shares or debentures to the members of the public. So because the company is there to be registered, those shares or debentures can only be issued can only be issued by the promoters on company's behalf. And in this case, we are saying the promoters here can actually now be paid a commission because now they have issued the shares to the members of the public on company's word, on a company's behalf. Number 6 is that the promoters can also be rewarded by given an option to buy the shares of the company at a price lower than, or basically at their par or their face value after the market price of those shares have done what? Increase. So in this case, we can say they can be rewarded by being given an option. An option is a privilege. They are given a privilege to buy company shares, shares at par value after the market price has done what? After the market price increases. After the market price increases. Generally, whenever you are buying the shares of the company, you should buy the shares at the market price. If the shares currently are trading at a price of 40 shillings in the securities exchange market, then you should buy them at that particular price. But in this case, we are saying if the par value per share, and actually the par value, you have to know it is the value of each share, which is stated in something called the company's memorandum of association. Because whenever you are registering a company, you must register a company with a certain amount of share capital. For example, in this case, you can register a company with a share capital of 100,000, and this may be divided into 10,000 shares. 10,000 shares, each share having a value of 10. So this value of the share, which is stated in the memorandum of association, is the par, the face, or the nominal value. So therefore, in this case, we are saying if the par value per share is 10, and maybe currently the shares in the securities exchange market are trading at a price of 30, then you are saying one way in terms of how the company can reward the promoters is giving them a privilege or an option to buy the shares at a price of 10, to buy the shares at a price of 10, despite the shares having, or despite the current market value of each share being how much? Being 30 shillings, So that is basically the other way through which the promoters can be rewarded. I think the last one is that the promoters can also be rewarded by accepting a cash payment, from directors, once the company is registered. Once the company is registered. So the directors, for example, in a BOD meeting, they can pass a resolution that we need to reward the promoters. We need to reward, or maybe we need to pay a certain amount of money to the founders of this company. So once that resolution has been passed, then what will happen is that the promoters now will be paid that particular cash, basically by the directors. But we are saying that this can only happen once the company has been been registered. So therefore, generally here what you have said is that the promoters, one, we have said, are not entitled to any salary from the company, to any remuneration from the company, simply because they are acting on behalf of a company which is yet to be registered. And therefore, we have said the company here cannot be able to enter into a contract with the promoters that once the company is formed, the company will be able to reward or to pay a commission or even a salary to those who promoters. But in this case, we are saying it is always fair for the promoters to be rewarded for their effort to register and also to forward the company. And therefore, you have said that these are some of the ways through which now the promoters can be rewarded for their services. Equally, this is a very, very common question whereby you can be required to discuss by the examiner how the promoters can be rewarded for their services in the company. So I hope we are together up to that point. Are we together up to that point? Are we together up to that point? Are we together up to that point? Dagote, JK, Mary. Are we together up to that point? Walter, are we together up to that point? Are we together up to that point? Okay, so if we are together, I think then we can be able to proceed. And basically discussing on the other aspect relating to the promoters, and that is the liability of the promoters. The liability of the promoters, the liability of the promoters. Now, what do you mean by the liability of the promoters? Now, in this case, we are talking of all the liability. Basically, we can say these are like the actions which can be taken by the company against the promoters. In most of the cases, if the promoters breaches their fiduciary duties. So, if you can be able to recall, we have said a promoter here is basically a trustee of the company to be formed. So, therefore, anything which is done by the promoter, it must be for the benefit of the company. It must in good faith. And basically, the promoter should not be able to do anything to benefit himself, but it should be, or whatever the promoter does must be meant to benefit the company. Therefore, in this case, you have said, as a trustee, the promoter has three fiduciary duties: the duty to act bona fide. I think we have already discussed this in details. The duty to act bona fide, the duty of proper accounting, and basically the duty of disclosure. The duty of disclosure. But there are some instances whereby the promoter breaches some of these duties. He made a secret profit, he never disclosed that. Maybe he never properly accounted for any amount of money which was given to him or her. Or, for example, the promoters never acted in the best interest of the company. So if that is the case, which actions then can be taken by the company against such a promoter? Against such a promoter, number one, we say that the company may sue the promoter for the breach of the fiduciary duties. So meaning that the company can sue the promoter. We can talk of legal action. Legal action basically is whereby the company do what? The company sue the promoter, for the breach of fiduciary duties. And actually, the company would be doing this in order to recover damages. In order to recover what? Damages. I hope you can be able to recall from whatever you did in the introduction to law and governance that when talk about the damages refers to the financial or monetary compensation, which can be awarded to you. If a wrong is committed to you, a civil wrong is committed to you, you go to a court of law, you take a legal action against now the other person, the person who committed that civil wrong to you, you can be awarded damages by the court of law. So therefore, in this case, we are saying the company can take a legal action against the promoter in a court of law in order to recover damages simply because the promoter breached his fiduciary duties. Number two is that the company can be able to do what? Can be able to avoid. So basically the question, there is a one which I'm looking for here, and that is basically the rescission of the contract. Rescission of the contract. So what do you mean by rescission of the contract? Rescission of the contract is whereby the company will be able to pull out or basically to avoid that contract which was entered into by the promoter in case, for example, the promoter had some personal interest. So meaning that if during the formation of the company, the promoter here entered into a contract with a third party, but on company's behalf, but for example, the promoter here had some personal interest. So he entered into that contract with a third party in order to directly or indirectly benefit, and the promoter never disclosed that. Or basically, he either disclose now that to the other promoter. So if the company is able to establish that the promoter entered into this contract with a third party because the promoter had a personal interest, then in this case, we are saying the company can be able to do what? Can be able to recede, or basically the company can be able to avoid this contract. To avoid or to recede is that the company can pull out of that contract on the basis that the promoter entered into that contract for his or her personal what gain, or basically what interest. So equally in this case, if maybe the promoter acted fraudulently, the promoter acted fraudulently. Equally in this case, he can also be sued in a court of law. In a court of law by who? By the company. He can be sued in a court of law in a company. So this whereby maybe the promoter acted or basically did a number of things, maybe with an intention to do what? With an intention to steal from maybe the members of the public. So if the promoter does that, he can still be sued in a court of what? He can still be sued in a court of law. So the other action which can also be taken against the promoter is recovery of the secret profit. Recovery of a secret profit. Remember, you have said that one of the fiduciary duty of the promoter is that if he make a profit which is not known to the other promoters, he must be able to disclose that. And therefore, if a promoter basically made a profit, which the other promoters are not aware of, he never disclosed that. Once the company is registered and the company has those facts that the promoter made a secret profit, then the company can be able to take the necessary actions to do what? To recover that profit. To recover that what? Profit. The other legal action which can also be taken against the promoter is that if during the preparation of the prospectus, the promoters included false or untrue statement, they can be sued in a court of law. They can be sued in a court of what? Of law. Recall in this case, we have said that a prospectus is basically a document which is prepared by the company to invite the members of the public to buy the company what? Shares. So if the promoters included statement which was false or untrue in the prospectus, then they can be sued in a court of law. Recall in this case, a promoter is basically a document which contains information about the company, and basically that information which is contained therein is to try and convince the members of the public to come and buy the shares of the company. So if the promoters, we are saying, included information which was false or untrue, then in this case, we are saying they can be sued in a court of law, maybe by any member of the public who relied on such information which was untrue or basically which was false, and maybe ended up buying the shares of what? Of the company. So these are basically some of the actions which can be taken against the promoter in case the promoter breaches some of the duties which he is supposed to undertake, specifically during the formation of what? During the formation of the company, during the formation of the company. Okay, so maybe first of all, we can just take a short break of 10 minutes, and then once we come back, I want us to discuss on this, the preliminary or pre-incorporation contracts. Pre-incorporation what? Contract. So in this case, we are going to define what are pre-incorporation contracts, and also we look on some of the legal aspects relating to this what? To this contract. So therefore, I think we can first of all take a short break of 10 minutes. I can see that exactly 1 p.m. So we take that short break of 10 minutes, and then we come back at 1 what? We take a short break of 5 minutes or 10. Dagote, Walter, Mary, we take a short break of how many minutes? 5 or 10? Or even 15? We come back at 1:10. We come back. Let's just take a short break of we take a short break of 10 minutes and then we come back at 1:10. So see you after that short break. Here. Yes, and I want us to discuss something called the preliminary or the pre-incorporation contracts. So as the name suggests, pre-incorporation. So these are the contracts which are entered into by the promoters before the company is incorporated or before the company is registered with the registrar of a company. So therefore, this refers to any contract which is entered into by promoters, entered into by promoters on company's behalf, before the company is registered. Before the company is registered. Now, can the company be held liable for this particular contract? So if this particular contract which were entered into by the promoters before the company was incorporated, those contracts are breached, can the company be held personally liable? Automatically no, because what I've said here is that a company is only regarded to be a legal entity, once the company has been registered. Once the company has been registered with the registrar of companies, and therefore until such time, until the registrar registers the company is not regarded to be a legal entity, and as such, the company do not have a contractual capacity. Contractual capacity is basically the ability of the company to enter into a contract. A company will only have this contractual capacity once it has been registered with the registrar of companies. It is the only time the company can be able to undertake contract or can be able to enter into contract. And therefore, this particular contract which are entered into by the promoters before the incorporation, before the registration of the company cannot be held liable in case they are breached. And therefore, here we say that the promoters are basically personally liable for all pre-incorporation contract. They are personally liable for all pre-incorporation contract. If a pre-incorporation contract is breached, the company cannot be sued in a court of law simply because the contract was entered into before the company had a contractual capacity, and therefore the third party who entered into that contract can only go to a court of law, take a legal action against who? Against the promoters. Against the promoters. Now, in this case, we have a certain reference case. Remember, in this case, when we talk about a reference case, this is a case you can be able to refer to as far as this legal aspect is concerned. We have said contracts which are entered into before the company is incorporated, the company cannot be held personally liable, but the person to be held liable are who? Are the promoters. So we have a reference case here, a case of Kellner versus Baxter. It was a case of 1866. And the first thing you must be able to recall is that in case you're given such a case, this is automatically a civil case. Why is it a civil case? Because it's a case involving two individuals here, two parties here. So the first party in a civil case, this is something you did in the introduction to law and governance, is the plaintiff. This is the plaintiff, whereas this is the defendant. Whereas now Baxter is who? Is the defendant. So this is a person who had gone to the court of law to take a legal action, whereas Baxter is the person who had been sued. Now, what are the facts of this particular case here? The fact of this case is that here a company was formed. Formed in order to buy a hotel. From this particular person here, who is known as the Baxter. So we are told a company was formed to buy what? To buy a hotel, not from Baxter, sorry, because this is the person who had been sued. So, but basically to buy to buy what? To buy a hotel from a person who was called Mr. Kellner. So remember, in this case, we have said Kellner, as far as this particular case is concerned, is the plaintiff. So a hotel was actually formed to buy a hotel from Kellner. But before this particular company was formed, or actually was registered, a contract was entered into on its behalf by this person here, by this person. So before the company was registered, was fully registered so that it could be able to buy the hotel from this particular person. So we are told a contract was entered into. A contract was entered into by Baxter. So meaning Baxter was basically a promoter. He entered into a contract on behalf of this company he was registering, and this contract was to buy wine, which automatically was to be sold in this particular hotel once the hotel was acquired from who? Was acquired from Kellner. Now, what happens is that the wine, or actually that contract for the purchase of wine was concluded, and the hotel was acquired. The wine was delivered, and before this particular wine could be paid for, this company was liquidated. This company was liquidated. So the company was liquidated before even this particular wine was paid. Now, a question here arises: who was supposed to pay for this wine? Is it the company, or is it now the promoter who is the Baxter, who had entered into that contract on company's behalf before the company was incorporated? So in this case, because the wine was not paid for, automatically the person who had sold that particular wine to the company, and that is this particular person here, went to a court of law to take a legal action against the promoter. So remember, we have said that one of the promoter who was in charge of forming that company was who? Was Baxter. And therefore, once now the case was heard by the court held that because that contract which was entered into by Baxter on company's behalf, it was entered into before the company was incorporated or before the company was held, the company could not be held liable for that contract. So the person who was held a person liable was Baxter, and therefore Baxter was required to come in and pay for this particular wine, which had been bought from Kellner and which had not been paid for at the time the company was registered. Now, this particular reference case is to try and illustrate that if you enter into a contract on company's behalf as a promoter before the company is registered, then in this case, we are saying you'll be held personally liable in case that particular contract is breached. So in case the contract is breached, then you'll be held a personally liable. Now, here we have various legal principles which governs this particular contract. So we can talk of the legal principles. In this case, we'll talk about the principles. Principles are just like the rules. Which rules or which legal provisions governs this particular pre-incorporation contract? Number one, we say pre-incorporation contract are basically null and void. Pre-incorporation contract are null and void against the company. Are null and void against who? The company. So meaning that if a contract is entered into by the promoters before the company is registered with the registrar of companies, those contracts do not have any legal implication as far as the company is concerned, because you're saying if the contract are breached, the company cannot be held person liable. So the person who can be held liable is who? Is the promoter. So therefore, as far as the company is concerned, those particular contracts do not have any legal implication, do not have any legal implication. Number two, we say that the company cannot ratify a pre-incorporation contract. Cannot ratify pre-incorporation contract. So basically, in this case, when we talk about ratifying is basically like adopting, is like the members of the company cannot pass a resolution that the company now will be liable for those particular contracts. So once the company has been registered, in a general meeting, the members of the company cannot pass a resolution that the company will be held liable in case those particular contracts are breached. That cannot happen because we are saying this contract was entered into at the time the company didn't have contractual capacity, and therefore, even after the formation of the company, this contract cannot be ratified. The members of the company cannot pass a resolution approving that the company will be held liable in case those particular contracts are breached. Number 3, we say the company cannot sue the third party, for the breach of this contract. So if the contract is breached now by the third party, the company cannot be able to sue the third party, simply because those contracts, as far as the company is concerned, they are null and void. Null and void means that the contract do not have any legal implication. Number 4, we say that third parties, or basically the third party, cannot sue the company, So in case the contract is breached maybe by the company, it is not possible for the third party to do what? To sue the company. Then number 5, we can say that the promoters are personally liable for all pre-incorporation contracts. So in case a pre-incorporation contract is breached, the person who is to be held personally liable is the promoter. So the third party in this case may decide to go to a court of law and basically take a legal action against now the promoter and not the company, So therefore, in this case, we are saying that the promoters here will be held personally liable. In case of particular contract breached, the person who can be sued in a court of law is not the company, but rather in this case, it is who? It is the promoters. But in this case, we are going to look on some of the ways, some of the mechanisms, or basically some of the mechanisms which can be used by the promoters to avoid their personal liability. And final number 6, we can say that the company after incorporation may enter into a new contract to execute or to carry out this particular contract through a process called novation. Novation. So basically what that means is that once the company has been registered with the Registrar of Companies, the company can enter into a new contract with the same third party, basically to execute or to perform that contract. Like assuming in this case, during the formation of the company, the promoters here entered into a contract with a third party, that this particular third party here will, for example, sell an asset to the company once the company is registered. Now we are saying this contract between the promoters and the third party, as far as the company is concerned, it is null and void. So if the contract is breached, the company will not come in fair. The company cannot sue. The company cannot be sued. But you're saying once the company has been registered with the Registrar of Companies, the company can enter into a new contract with the same third party. So meaning that what will happen here is the promoters will fall out, and the company will come in and replace who? And replace the promoters. So that a process through which the old contract between the promoter and the third parties is terminated and replaced by a new contract between the same third party and the company, we refer to that particular process as what? As novation. And if that now happens, and this contract is breached, automatically the promoters will not be held personally liable because the old contract between the third party and the promoters has been substituted, has actually ended and replaced by a new contract between the same third party and who? And the company. Now, in this case, I want us to look on some of the ways, or actually some of the mechanisms which can be used by the promoters to avoid being held liable under the pre-incorporation contract. So we can talk of ways of avoiding personal liability. Remember, in this case, we are saying If, for example, you're a promoter, you are involved in the process of registering a company, and you happen to enter into a contract on company's behalf before the company is registered, then you're saying the company is not or that contract, as far as the company is concerned, is null and void, and therefore, if the contract is breached, you are the person to be held personal liable. But how can you be able to avoid this personal liability? Because in this case, you are entering into that contract on company's behalf. So one way in terms of how you can avoid your personal liability is basically by including a clause in that contract, including a clause in the contract, that you can only be held personal liable as a promoter. You can only be held personal liable as a promoter, up to the date of a company's incorporation. Of companies what? Incorporations. So whenever you're signing this contract with a third party as a promoter, you make sure that there is a clause. There is a clause or a provision in that contract that you can only be held liable up to the date the company is incorporated. So meaning that if the contract will be breached after the company is registered, then the third party cannot be able to go to a court of law, take a legal action against you, but he can only sue the company. There is a clause, there is a provision in that contract as far as that is what is concerned. Number two is that the promoters can also avoid their personal liability by first of all doing what? By first of all incorporating company. So first of all, they can do what? They can incorporate the company before entering into any contract. Before entering into any contract on company's behalf. So as a promoter, in order to avoid being held liable for this contract you are entering into on the company's behalf, first of all, ensure you have registered a company. And therefore, later on, you can be able now to enter into a contract on company's what? Behalf. Because if you enter into a contract on behalf of a company which is already registered and which do have contractual capacity, in case the contract is breached, the company is the one to be held personally liable because you entered into that contract at the time the company had a contractual capacity. Number three is that as a promoter, you can also avoid your personal liability by ensuring that once the company is registered, it enters into a new contract with the same third party under the process we have referred to as what? Novation. Remember, in this case, we have said novation is whereby the contract which was entered into between the third party and the promoters before the company was registered, that contract will be terminated or that contract will come to an end and replaced by a new contract between the same third party and who? And the company. So therefore, as a promoter, you can ensure, you need to ensure that once the company is registered, it enters into a new contract with the same third party to execute the pre-incorporation what? The pre-incorporation contract. Number four, as a promoter, you can also avoid a personal liability by entering into a contract which is in draft form only. You enter into a contract which is in draft form only. Draft form means that as a promoter, you just negotiate a contract on a company's behalf, but the contract will only be executed once the company is registered with the Registrar of Companies. So you are just negotiating a contract with a third party, but maybe the contract will be signed once the company has been registered. So that ensures that the contract will be signed on company's behalf, which has already been registered. And in case the contract is breached, automatically you cannot be held liable as who? As a promoter. As what? As a promoter. And finally, number five, you can also avoid a personal liability as a promoter by entering into something called the specialty contract. So what are specialty contracts? Specialty contract, also known as contract at the deed or contract at the seal. These are those particular contracts which you enter into on company's behalf, and basically you sign. Whenever you're signing that contract, you clearly indicate that you did that as an agent of the company. So you're not signing that contract as if it is your own contract, but you're signing as an agent of who? Of the company. So you're an agent of the company. So in case the contract is breached, automatically we know that an agent is not the person who is held liable, but is the principal. So that contract was entered on, or was entered into on whose behalf? It was entered into on company's what behalf. So therefore, in this case, or if the contract is breached here, the person to be held liable is not you as a promoter, but basically the person to be held liable is who? Is the company, because the promoter here purely acted as who? Acted as an agent. Yes, so those are some of the ways or some of the measures which can be put in place by the promoters to avoid being held liable for those particular contracts which they enter into on companies' behalf. Behalf. So next, I think maybe we are done with the aspect of promoters. So next, I want us to look on the process or the steps of registering a company. Registration of a company. Registration of a company. Now, when we talk about the registration of the company here, basically we are talking of, or we are referring to some of the formal steps, or basically the steps which are involved during the registration of the company. If you want to register a company, which steps do you need to follow? So maybe you can just talk of, we can talk of those particular formal steps which are involved during the formation of a company, involved during the formation of the company. Number one is the reservation of a company's name. Reservation of the company's name. So the promoters here will basically need to come up with 3 names. They will do a name search, and nowadays, if you want to register a business name, you do a name search in eCitizen. You go to eCitizen, you must create an account with eCitizen, you log in, you'll be able to do a name search. Basically, you must have 3 names, not just one name, 3 names. You'll be able to type those particular names. To input those names, you pay around 1,000, or I think 950 shillings. You do a name search. So one of the name may be approved, or maybe all of them are rejected. So if they're rejected, you are also required to come up with 3 other names. You do a search again. You do a search what? A search again. So therefore, the first thing which the promoters need to do during the formation of the company is to reserve the name. To come up with the name of the company, they do the name search, and then once the name is approved, the name will be reserved. The name being reserved means that no other business can be registered with such a name. So actually the name will be reserved for a period of 30 days. So after this, the promoters will then be required to proceed and prepare the documents which are required during the registration of the company. So these are those documents which the promoters are required to prepare and basically file with the registrar of a company. So here we have a number of documents which must be prepared, including things like the memorandum of what? The memorandum of association. The memorandum of association. We also have other documents such as the articles of association. We have the statement of capital. The statement of what? Of capital. So they need to prepare this particular document, and basically this document by the end of the day will have now to be filed with the registrar of companies. So then from there we have the stamping of the document. Stamping of the document. So what do we mean by the stamping of the document? So stamping of the document basically involves payment of something called a stamp duty. A stamp what? Duty. So remember, in this case, I've said, if today you're registering a private company, there is an amount which you have to pay to the government, which is called stamp duty. Stamp duty. So the stamp duty depends with the amount of the share capital. So I think the minimum stamp duty, I think, should be around 11,000. 11,000. So you pay that amount, to the government, and then the document will be stamped as an evidence that that amount has been paid. So once that happens, you pay that stamp duty. Then from there you proceed and basically make an application with a person called the registrar of companies. You make an application with the registrar of companies for him to be able to register the company. Now, when making this particular application, for the registration of the company, there are a number of documents which must be filed with the registrar of companies, So one of it is called CR12. Sorry, CR1, not CR12, CR1. CR1, basically this is an application for or the company's registration form. So one of the documents which you must, and remember in this case, we are saying all this is done online. So if today you are registering a company, you don't need to go to the office of the registrar. You just need to have an e-citizen account. E-citizen account. Everything is done online. Everything is done online. So one of the documents we are saying you must file with the registrar of companies CR1, which is the company's registration form. The company's registration form. Maybe this one will include the name of the company and maybe other details. So the other form, this one is called Form CR1. The other one is Form CR2. And this one, CR2, is basically the memorandum of the company, or basically the company's MOA. The company's MOA with the information about the share capital. So you must be able to come up with the with the memorandum of association, which will be including the share capital of the company. So that form is called CR2. And then we also have CR8, Form CR8. These, remember, we are saying are forms which you must be able to complete. And basically, this one includes information about the company's registered address. The company's registered address. So when talk about the company's registered address, this is information about the company's postal address and also the postal address of the directors. If maybe a communication is to be done by the directors, it will be sent to which maybe registered post office. And the other form is something called Form CR10. But mostly this one applies to private companies because this one is include information about the company secretary. If you can be able to recall yesterday, we said that all public companies are required to have a company secretary, but we said a private company is only required to have a company secretary if the share capital of this company exceed an amount of 5 million. So therefore, mostly this particular form here, CR10, this one is usually required for what? Is usually required during the registration of what? Of the company. So these are basically some of the documents or some of the forms which must be uploaded in eCitizen, submitted to the office of the registrar of companies when making an application for the registration of what? Of the company. So once the application for registration has been done, the other step is basically the registration of the company, and issue of a certificate of incorporation. So once the office of the registrar of companies receive this particular application, it will be able to peruse those documents, to check those particular documents which have been uploaded and submitted to his office. If the office of the registrar of companies is satisfied that all the legal requirements regarding the registration of the company have been complied with, then what he will do, he will register that company and basically issue something called the certificate of incorporation. Now, in this case, if you can be able to recall, we said that once a private company has been registered, issued with this particular certificate of incorporation, it can be able to proceed and start operating immediately. But a public limited company, we said, cannot be able to start operation until now it has received another certificate called a trading what? Called a trading certificate. So therefore, a certificate of incorporation is a certificate issued by the registrar of companies upon the registrar registering a company. And this particular certificate is issued by the registrar as a conclusive evidence that all the requirements of the Companies Act in relation to the registration of the company have been complied with. And actually now he signs that particular certificate. And once the company has been issued with that certificate of incorporation, the company is regarded now as a legal entity. The company can be able to go ahead and basically enter into a contract with third parties, and also the company can be able to sue or be sued. So which are some of the details which are contained in this certificate? That certificate of incorporation issued by the registrar of companies, which details do you think are included there? There are obvious details, like one, the name of the company. The name of the company must be captured in that certificate. Number two is the information about the liability of members. Is the liability of members limited by shares or limited by guarantee? That certificate still will also be including information about a unique registration number of the company. So once a company has been registered, a company is given a unique identifying word number. The certificate will also be including information about the date of the company's registration. When was the company registered by the registrar? It will also be including information about what? It also includes information as to whether the company is private or public what? A company. So those are basically some of the details or some of the information which will be contained in this particular certificate here, which is called Certificate of Incorporation. Certificate of Incorporation. So for today, I want us to stop at basically that particular point. So once we meet in our next session, we will be discussing on something called the constitutive document. And actually, talk about the constitutive document, we know that these are those particular documents which are regarded to be the constitutions of what? Of the company. In this case, we have two constitutive documents, the Memorandum of Association, MOA, and also something called the Articles of Association, in which case we will be able to look on the definition of each of these particular documents. We look on the content of each of these particular documents and maybe other legal provisions governing each of these particular content. For example, what or how should this particular document be prepared? What is the legal effect, and so on. So those are basically some of the issues we will discuss in our previous session. In our previous session, and hopefully we will be able to maybe wind up with this topic here, because we have a number of issues to discuss about the constitutive document, the content, the definition, the legal provisions, and so on and so on. Yes, so therefore for today, I want us to stop at that particular point.